Our focus today will be human rights in the UK. The previous lecture should have gotten you to the grips with what Dicey's rule of law is. You will now see how the rule of law is central to the protection of human rights. The UK lacks a written constitution. As such, human rights in the UK have always been protected through regular law, also known as common law. Through the decisions of courts rather than through a written constitution, Dicey himself found this approach of courts protecting human rights preferable. Under the rule of law, the government needs to be regulated by an independent judiciary whose control is to safeguard the individual from arbitrary power. Section 6 of the Human Rights Act 1998 makes it unlawful for a public authority to violate human rights set out in the European Convention of Human Rights. This ensures that individuals enjoy rights equally, that government power is restricted, and that international human rights law is followed. Both domestic and European courts do nonetheless respect the sovereignty of the democratically elected parliament and their law. UK courts have always been able, subject to parliamentary sovereignty, to interpret legislation in a human rights friendly manner and to subject government decisions to restrict judicial review where human rights have been violated. As in R versus Ministry of Defense ex parte Smith, the traditional approach of safeguarding human rights has since been strengthened. Here's how. The European Convention of Human Rights is an international treaty that is based on the human rights protection. The UK is a member of the treaty, and under Article 1 of the treaty, the UK must secure to everyone within their jurisdiction the rights and freedom defined in the Convention. These rights include, but are not limited to, the right to life, the right to freedom, and the right to a fair trial. To effectively incorporate those rights into domestic law and to allow UK courts to apply Convention principles, the Human Rights Act 1998 was passed. If it now works with the common law to secure human rights, in essence, the HRA 1998 is a bridge between European law and UK law. Section 2 of the HRA provides that when a court is determining a question involving any convention right, it must take into account any judgment, decision, declaratory or advisory opinion of the European Court of Human Rights so far as it is relevant to the proceedings. Do note, however, that Section 2 does not insist that the courts have to apply such decisions. Merely taking them into account is theoretically seen as being sufficient. The domestic courts will generally follow European case law where the European jurisprudence is clear and would involve domestic law being inconsistent with the Convention. This was seen in the case of R versus Secretary of State for the Home Department ex parte Taylor and Anderson, whereby the Court of Appeal held that it would be improper for the domestic courts to decide a case in a way that was contrary to the application currently being applied by the European Court of Human Rights. However, UK courts may choose to follow domestic law where the European Court has not ruled directly on the legal issue. Here the case of REP and others applies, whereby the House of Lords held that where the European Court has not laid down a definitive interpretation of the article's application, the domestic courts were not bound to follow these decisions and could give their own interpretation to them. Section 3 of the Act states that so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with Convention rights. If a court is satisfied that the provision of primary legislation is incompatible with the Convention right, it may make a declaration of incompatibility through Section 4, subsection 2 of the Human Rights Act 1998. Such a declaration is used as a last resort, and usually Parliament will change to law to make it align with the Convention right. Through a declaration of incompatibility, Parliament's sovereignty is preserved. The courts aren't allowed to strike down the incompatible law. the law will continue to operate despite the declaration. It is, however, expected that the offending legislation will be amended so as to comply.